Okay, members, welcome back. Members, welcome back, and we will actually proceed now with where we left before the break, and we'll be tackling articles 258 and 259 under property orders.
Might I say?
Yes.
But,
Go ahead.
Chair and members, by way of introduction, the significant new matter, and we do have new material here, relates to the distribution of property when not only a marriage breaks down, but also when an en ménage relationship breaks down. This is clearly focused on in Articles 258 and 259. There is some continuation of existing rules for married couples. There is an extension to en ménage relationships, and there is also an increase in the possible rights of couples who've been divorced. So this is the first direct reference to the en ménage relationships. There are, by way of forewarning, so to speak, there are in the draft 9 references, new references to the situation of en ménage relationships, and they will all be identified clearly to you. It is quite possible that the debate on 259 is going to a degree predetermine then the consequences for the other references in the code. The situation on dissolution of a domestic relationship has been well covered this morning in relationship to what happens currently when a marriage breaks down. The situation where an en ménage relationship breaks down, this is the current law, is quite different. We have the situation, you'll remember, where each party owns their own property, and absent the marriage certificate, then at the end of the en ménage relationship, each party is simply left with their property, and there is no access to a court to say, well, my departing female partner should give me part of the house she owns. That is possible in the marriage relationship or divorce relationship, but not here. The situation then, the courts have, we're told and we read in the cases, constant problems, given, I guess, that 80% we're told of the domestic relationships are en ménage, constant problems where you have long-term en ménage relationship, and the best that the non-property owning party can obtain is an order for return of any unjust enrichment, and that relates specifically to property. So if contributions to the property, but these are cash, so that if one of the parties owns the house, but the other, for part of the relationship at least, has paid off or contributed to the mortgage payments, then they can say, oh, I contributed these sums to reduce the mortgage. They have no right to a share in the house, but if they can produce the pay dockets or the bank slips, they will get back what they put into the partner's property. And that is almost invariably much, much less than if they were had been married. And the critical thing is it never gives access to what is owned by the other party. The proposal in the bill from the committee proceeded on a number of bases. Of course, practicality and fairness, given the number of cases litigated, and the variability actually of court judgments, because the courts don't think simply giving back your mortgage contribution is fair after maybe 20 years of a relationship. So they have struggled to give a bit more. The revision committee was concerned that this was this difference was potentially in breach of the constitutional right to freedom from discrimination on any ground. The discrimination here is, do you have a marriage certificate or not? But there is significant property consequences from that. The Constitution also says that the family, and not restricted to the married family, the family is to be protected. And further, the Constitution speaks of diversity. This is a sovereign democratic state in which there is diversity and tolerance. So against that background, the committee worked through a number of proposals which you now see formulated in the bill, and particularly 259, but there's an extension of the existing provision in the Status of Married Women Act that is in 258. So the basic proposition, and you'll see in 259 there are a number of details, but the basic proposition is that a long-term stable de facto relationship, the emménage relationship, should, on the collapse, give right to some access to the property of the property holding partner. So that's the general principle, to try to establish a fairer distribution of property when a domestic relationship breaks down. As far as the marriage is concerned, you'll see that there is a proposal there which advances the right of the divorced couple, and it says, well, if the relationship has existed for 7 years, then there's a presumption that the parties will share the property. So up to 7 years, the current law would be maintained. Party would go to the court and say, please make an order for me and give me some of my former spouse's property. But after 7 years, the proposal here says, well, presumption should be that the parties would then share. So that's a broad overview of the of these two provisions, which, as I say, are the first of about 9, which extend certain rights and, in some cases, duties to parties to en ménage relationships. Thank you, Mr. Chair.
Thank you, Professor. Yes, Honorable Roncal.
Thank you very much, and thank you for the explanation, Professor Angelo. I think this is one of the aspects of the revision which has been talked about the most, and I think we need to get it clear, because a lot of married couples are in fact a bit worried about this provision. So I will just highlight one or 2 points that we need to get clear so that people understand. One, from 258 and the reading of 258 and 259, is it clear that a man or a woman who is married, but then for some reason they, or in the relationship goes through difficulties, and say the man leaves the family house without getting divorced, leaves a ménage with a woman for 7 years, that even though that man lives with another woman for 7 years, that the family, the property acquired during the marriage will not be affected by the ménage relationship. So I think this first point needs to be made clear. Secondly, that two persons living a ménage who agree to leave a ménage are putting themselves in a situation where the house that they live in, whether it be a house belonging to well, one of the partner, whoever, after 7 years, the possibility of this house, if the ménage relationship breaks down, of that house also being included in the distribution of the property. So this must again be made clear. So based on that second point, is there a possibility, similar to what we've discussed before, for the man, if the house belongs to him, for the man to say, this is my property? That sort of declaration of assets before a notary. So that when he enters into a ménage relationship, should that relationship break down, that the house will not be included in the distribution of the property. So I think if these 2 points are made clear, and that two people entering into a ménage relationship realize that this is what we are putting ourselves into, that it will not be a question of the relatives upon upon the death of their brother, because this is a problem when death happens, where members of the family, the sisters and the brothers, come and say, this is our house. And there I'm talking of say inheritance. Okay, I've inherited a house and I've got this, I'm living a ménage. I've lived a ménage for 40 years, and upon the death of the person who got this gift, that the other members of the family come in and fight. So that if it be made clear that in this case, it will be the surviving spouse. I mean,
Yes.
I need clarity there.
Yes.
It will be the surviving spouse who will,
A ménage
a ménage spouse, yes, the a ménage spouse
who will,
who will inherit the house and the property. I think if these 3 points are made clear, then maybe the population will see things in a new light. Because the fear, especially the fear that somebody who is married without being divorced walks out and is not interested in getting a divorce, that the family, the married family, may be affected. I think I want clarity.
Thank you, Honorable Ramkalawan. We will allow the professor to clarify these 3 points first, and then we'll take other questions. Professor.
yes, just very briefly, members, the intention, and if it's not clear, I'm sure it can be clarified. The intention is that the acquisition of property is in relation to each relationship, so that the former marriage, the new relationship doesn't borrow or take from that, but you start on the new day, so that the intention was that is protected. So if the consecutive relationships, each one is terminated. And the similar rule, and it's, I think, in 2591 at least indicated, is that it is again the acquisitions. So if the house were owned before and there's the inventory and it's recorded, then that is outside of the property that will be distributed equally at the end of the relationship. If I have that wrong, I'm sure the Honourable George can clarify. But that is the intention, and if it's not clear, then that's a defect in the drafting. Among the other 7 provisions, of course, are those relating to succession. And at the moment, the pattern has been, assuming this, then the succession would follow a similar pattern. Depending on the Assembly's views on this, I guess there will be implications for the situation of surviving partners. At the moment, the view expressed is the one that is incorporated in the succession laws.
Okay, thank you, Professor. Is that clear, Honourable?
Yes, I did.
Okay.
I did.
Yeah, Honourable William.
Thank you, Mr. Chair. Mr. Chair, before I go to this section, I beg your indulgence to go back to, there is one article that, well, I don't feel that we have exploited a discussion on it regards to Article 257. And I feel that we've completely closed the door and I would like to have the views of the lawyers here present and the honorable professor, because I know for a fact
I
that
was going to make a mention to that, but then I said no. It's a standalone article, and
Yeah, because-
that's it.
Adultery damages.
for a fact, I mean, within society, because nowadays we are being charged for moral damages, inconveniences. So I just want to leave that. But with regards to what the professor has said, I mean, I've got a text. Someone saying that if it's not a, if it's not a violation to avoid splitting up the, no, wait a minute. Isn't it a violation of rights since you are forcing someone to break up before the 7 years into a relationship to avoid splitting up their properties? Now, as it stands, you have the freedom to choose either you marry and share or you don't marry and keep what you have.
It's a right. It's a right, and it's the choice also of somebody who wants to either go into a contract of en ménage, go into a relationship en ménage, or if you want to actually bind yourself to marriage. This is also a right because you cannot force people to get married, but at the same time you cannot force people to stay en ménage or whatever. But it's a right that people actually enjoy. You want to say something, Honorable George?
Not on this point. I think that point, Mr. Chair, thank you
But
very
on
much, has
Article
been
257?
257. I just wanted to, 257 is a clause which says that where the marriage breaks down because of adultery, the party responsible, as it were, for the adultery will no longer pay damages, or the co-respondent will no longer pay damages for the breakdown of the marriage. Our old law, our old Matrimonial Causes Act, did not have this provision. So you were allowed, where there was an adulterous relationship which broke down the marriage, the innocent party, quote unquote, could claim damages against the third party, the co-respondent, the person who was committing adultery with his or her spouse. This was removed in 1993 as a result of the decision of the committee, the Divorce Reform Committee, in line with modern international practice. On the reasoning being that we moved away from fault-based divorce to no fault-based divorce. That's why we moved away from a ground of divorce, adultery, cruelty, desertion, to one ground, which is irretrievable breakdown, which acknowledges that in most cases, not all cases, but in most cases, there is a shared responsibility for the breakdown of the marriage. So it was felt that it was no longer appropriate because we had moved away from fault, for there to be damages for a fault for breaking down the marriage, such as adultery. And this situation obtains pretty much, well, in most modern countries. I'm sure there are a few which retain this, but we felt at the time that we had to move away from that. So that's why this disappeared. And all we're doing now is to restate the position.
Thank you, Honorable George. Honorable Audrey Vidot. Are you? Yeah.
Thank you. Thank you, Chair. Just on that point, and also on what the en ménage. In your system, the one, let's say, who is at fault, because you were mentioning yesterday sort of rupture de la vie commune. In our system, rupture de la vie commune is the person who enters the case, he's responsible for the breakdown of the marriage. The other one doesn't want to accept. And when you petition for that, you provide for maintenance for the other. Maintenance means the person must continue to have the same living standard as before.
Yes.
Mm? And is at no fault at all about that breakdown. Similarly, concerning this, we have divorce pour faute. It could be tort partagé, or one person, the one who is responsible for the fault, the other party would be liable to maintenance if the need arises, to maintain the same standard of living. Because when people get together, they are for some time, if for one reason or another it breaks, unless they are at fault, you should maintain the same standard of living. That's true for the children also. You must their alimony as far as possible. Yeah. These are provisions to think of when you think about. I don't know right now for that, when you move to it, when you say it's no longer at fault, it means you will compensate that person to a maintenance. I don't know if the law Seychelles right now provide for that. I mean, it's good to think about it as a policy. That's one thing. On ménage, I have a number of issues. Whatever policy decision is taken, a number of issues, conceptual. You enter into marriage, it's an acte juridique. C'est un accord de volonté en vue de produire du droit. Here you have two people, c'est un fait juridique, two people who live together, and over the years the kids are born, and then suddenly the other party wants half of the whole thing. My first question is, you are putting, il y a deux types de règles when we do it, soit des règles supplétives, that is, they are not imperative, they apply if you've not made a different choice. Or, if you have the règle impérative, you can't derogate, they will supplement your will. Here I've got the impression that the free will, people do not even know the consequences of what will happen, and they find themselves in a situation where they've not even thought of. And there is no opt-out of it. Comme si ça s'applique comme d'ordre public. I mean, think about the policy implications of it. There can be solutions to say, well, at least I think anyone who wants to opt for that type of lifestyle, let's put it like that, should know beforehand what would be the implications, whatever policy choice we make. You must also make it clear that en ménage, it means at most, if you decide like this, that when it breaks down and there are children, but someone who's married and there is divorce can get maintenance, can get a number of things. Even during the relationship, can ask for maintenance, which in the en ménage will not be able to get. It's not just 7 years, I think even shorter the church can apply. I mean, policy, how you draft it, how you leave the part for l'autonomie de la volonté. What part of it will be d'ordre public, having regard to children and so on? You have to think about the policy options you want. And also make it clear, you can't assimilate en ménage to marriage.
No.
You want to address the vulnerability of the person who over the years, out of love, live with this guy. God is my witness, they live together, they have kids, and then she's left her career and suddenly finds a younger woman more interesting, and she's lost her career. She's been pregnant a number of times, but the guy's patrimoine has increased. You want to set things in fairness. That's one thing to be done, which we can do already. But you have to sort of don't assimilate it, but you want to protect someone which out of that relationship, in marriage, the more so because of separation, you found a way to compensate by putting that. That's an attribution to the thing of separation. Yeah. Think about maintenance also, because it may happen that the person has given up a career to look after the children. It could be the man, the woman today, but it could be the man tomorrow, because women have careers. And it's for the best interest of the child that someone follows a bit more closely. You have to think of all those options, but important is to get your policy clear about how do you distinguish the en ménage and the marriage. You try to protect people who are out of that, because very often it's love, and love is blind, but they will find themselves avec la dure réalité patrimoniale un jour. As we say in French, même la rose a des épines. La rose a des épines.
Thank you.
After the dream, after the thing, then get back to reality.
Thank you, Mr. Domingue. Maybe there's also saying once bitten, twice shy, where you see a marriage breaking down, and the second relationship, the person will either say, no, I've been there before, I'd rather stay down a ménage relationship. So, but like Mr. Domingue said, the principle here is not to deviate from marriage. We should continue to give marriage its full importance in the society, but we have another situation where the society also has to think about how to take care of. Honorable George and then Honorable Vidot.
I just wanted to answer on behalf of the committee's thinking one or two points raised by Mr. Domingue. Clearly, there are a couple of situations that need addressing. One is the fact of the 80% of relationships which are en ménage. We cannot ignore that. It is in our society. That's how our society is composed of. The second one was, and we thought long and hard about this, do we address this? Do we conceptualize what this relationship is? Do we give it a name? Do we give it a set of rules, such as you are saying? Do we assimilate it to marriage? Do we not? Do we make it as a contractual union, as a civil union? Do we set out a set of parameters for it, which would be the ideal? We didn't. At the end of the day, we simply addressed two current problems, which are what happens to property upon breakdown, and secondly, what happens to property at death. So only those two narrow things are looked at, and we are doing the very bare minimum. Why? Because there are two problems which are current. Because of the 80% of people who don't get married, these problems are current and courts have to deal with them. And all we're trying to do is to set some rules to guide the courts when those two issues arise, with a view to sometime in the future regularizing what is an en ménage relationship. Is it marriage's poor brother, or is it something that is equal to marriage but has other legal consequences, or is it something that we should ban altogether in favor of marriage? So those are all the ideas for future debate.
So at present, we're not changing the definition of marriage and all that.
No, not touching marriage.
This is clear because, like Honorable Ramkaran said, the outgrow our days. We are playing with definitions and everything. Honorable Vidot.
Good morning, everyone. Thank you, Mr. Chair. My first question is a bit similar to what the leader of the opposition had mentioned earlier, but only the different scenario is that it could be either in marriage or in ménage. Is it possible for, if the spouse or the party inherited some property, the parents have passed away, and the woman or the man is the remaining heir to receive the property, and if they separate, instead of deceased, one of them deceased, but if they separate, will one of them be inheriting the property or the child will inherit? And my second question, in related to what Mr. George has also, Honorable George has mentioned, to define en ménage. Today, in our culture, in our lifestyle, we're having a man who's living two lives, en ménage. Okay? Could be a woman, but
One a ménage and one galant.
Could be both. I don't want to be biased. But we need to clear out, because I know some of our people out there wanted to know, especially we need to educate the kind of life that they are currently living right now. If, like I said, they have two partners, en ménage, more than 7 years, but they may have suction, but they don't know exactly if it's true. If their partner is cheating on them or something like this. What would happen if their property, in terms of dividing the properties, if they separate, maybe when they find out that they've been having two different lives? That's my 2 points. Thank you.
Okay, this is yeah. I will give the mic to Honorable Woodcock because he hasn't actually intervened at all. I think you're following up on what Honorable Vidot said. Yes. Please.
It's not only a question in regards to a man living a ménage with two women, or a woman living with two men. There are cases where certain married men, it's quite common in Seychelles, where married men also have is living en ménage with another woman. And one weekend he's living with the wife, the next weekend he's living with the concubine or the woman en ménage. So how do you reconcile the two, and how do you protect the wife from such cases? Let's say, for example, the man has been living with the woman en ménage for more than 7 years. There are cases that I know, in fact, whereby the men have been married for a number of years, 10 years, 15 years, and at the same time has been living with a woman en ménage for over 10 years, and they even have kids with both the wife and the woman en ménage. So how do you reconcile the two? How do you protect the married woman? Thank you.
Property acquired during the marriage cannot be transferred.
No vice versa.
The definition.
Yes.
The definition, maybe, because in Creole there is another definition. I mean, we have a ménage and then galant. Galant is the man, is a relationship where the partner goes off for a weekend, but then comes back to the family, to the family house. Ménage is where you are living permanently with somebody. So ménage and galant are two different relationships.
Let me add on what Honorable Woodcock has actually thrown at us. There are situations at the moment in our society where such relationships are actually taking place, and it's accepted. It's accepted for certain reasons. The married wife knows and accepts that the man is actually having another relationship, and the man shares 2 homes. Okay?
The children.
I'm not too sure if there's a lack of men.
Even looks after the children.
Yes, and children are born in the other relationship, and it's accepted. So this is a situation also that I don't know whether the civil code will. Yes, Honorable Woodcock.
In such cases, let's say the en ménage relationship breaks down, can the woman en ménage now, with a provision that is being proposed to be made in the law, can she claim a portion of the assets of a man? Assets, business, or...
No?
Mr. Speaker, the reason why Moses spent so long on top of the hill, on top of the mountain, was because
He was questioning.
well, when God said, okay, number 6, thou shalt not commit adultery, he said, no, it's too. Think about Seychelles. It's not going to work. It's not going to work.
I think Moses had many questions for God, and that's why it took so long. Yeah. Okay, Honorable Pile. Your name is here. Yeah.
Thank you, Mr. Chair. I was also grappling with this issue, but what I would like to clarify, in the case where a man already has a married relationship and he leaves the family home to sow his oats, so to speak, too many irons in the fire, does that count as adultery because there is no separation? Can the wife, the married wife, claim that this was an adulterous relationship? In this case, it would be an adulterous relationship because then leading to divorce, then disqualifying the other spouse from partaking into any property distribution. Or what I would like to clarify is that saved with the provision that we have currently. That's the first question. My second question is, if there is an issue from the second relationship, say Honorable Wawu was married, and then he goes out and sows his wild oats and has another child in another relationship. I'm not sure if he has. I don't know about that. So in that case, and perhaps the lawyers can educate us on this. In that case, will the children, the issue from the second relationship, have the same rights in inheritance as the children who are part of the relationship who are in wedlock? Would they have the same rights?
Yes.
That's the first question I would like to ask. Now, the second question now is in relation to properties that are in co-ownership. A lot of properties in Seychelles have not been distributed amongst the different heirs, and for a lot of reasons. People do not sign off on the subdivisions, etc. And you find that okay, somebody says this is my part of the property. I come in, I build a house there, and I live in an aménage relationship with a person without getting married. There are no issues from the relationship, no children, and the spouse that inherited the property is deceased. Now, does the aménage partner, the one who's surviving, can she now or he benefit from the inheritance, given that, let's assume there was already a house on the property which was not built by the two of them, which basically is an inheritance to the partner that has deceased, and basically the property remains in co-ownership. So are the original co-owners entitled to a share of that property, or is the spouse that has lived in that relationship, say 8 years, 10 years, 15 years, is he or she also entitled to the property? Because when I read 2591 says, makes a derogation other than property acquired by one of the parties on succession or from a third party or by will of gift or will. So can we clarify this? Because people have asked questions about this as to their rights in relation to properties. Thank you.
Okay. You want to clarify? We'll go in and then, or you want to?
Yes?
Okay, Professor. Then we'll go to
My understanding is that 2591 would preclude access to that property, and therefore it remains in co-ownership. It's acquired by succession, so that the co-ownership and the distribution that follows from that would take place in the ordinary course.
So, just to clarify that,
Yeah.
maybe Mr. Chair. So, in that instant then, maybe if the lawyers can chip in if they've had any cases similar to this. Given that we do have a lot of properties who remain in co-ownership in the country, what happens then to that surviving, let's call it the surviving spouse? How does she, I mean, she's been in the relationship, she doesn't have a way, and we've seen this, she doesn't have a way to use bank statements or anything or receipts or invoices to prove that she has contributed to the property. What is she left with if there is no issue from that relationship, that is, there is no children? Is there a provision, or does she have to make an application before court?
She have to.
What will happen?
Yes, Honorable Bansiri.
Thank you, Mr. Chair. Even though the property is held in co-ownership, the surviving spouse will inherit the share of that property which belong to the deceased spouse. This is what will happen. Yeah.
But not on Minaj.
Not now. No. 2591 is in respect of termination, not succession. It's when it is terminated inter vivo. In fact, it says so. Relationship ends inter vivos. So it has nothing to do with succession. Yes.
So basically, you want to clarify for the mic. So what you are clarifying in the case, for example, on Ram Kalawan raised that the people have been together for 40 years, and the property is still in co-ownership. The spouse is not married. That's what I'm saying. It's still an aménage relationship. Is the spouse entitled to what you're saying, that share which the partner which is now deceased inherited as a co-owner?
Okay. Presently, that common law spouse will not inherit, but there is provision under Article 745 of the proposed code. 745, which in certain circumstances she will inherit. She might not inherit if she comes into the succession along with a married spouse. She might not inherit because that will go to the married spouse.
Yes.
But if she is alone, there is no married spouse, she will inherit, as per the proposed 745. But currently, as per our civil code, presently, she will not inherit.
745
Well, it says 7451. It says if there is either surviving spouse or partner, then the one will inherit, either the surviving spouse or partner, if there is only one of them. 752 provides that if there is a surviving spouse, a surviving spouse and a partner, surviving partner, that surviving spouse will inherit
To the exclusion.
yeah, to the exclusion of the surviving partner. Except that the surviving partner will inherit what was in the all movables that was in the house that she was sharing with the deceased spouse.
So basically, not to labor the point, she will get the movables, but she will have to vacate the house
Under the proposal.
Yeah.
under the proposal.
But of course, we are also, unless
Half of the house.
the spouse who is an inheritor makes a will, leaving a ménage, makes a will
Oh, yeah.
to say my part of the property will belong to my partner, a ménage, a partner.
And he can do so even in respect of a matrimonial home. He's sharing with his wife.
With his
And give it to
to
surviving partner.
yeah. Okay.
Okay. Does that address all the concerns? Okay.
Chair, just I mean, clarification, because you're taking policy decisions. You mentioned, I've looked at
Oh, no, we haven't.
clause 745 2B, where it talks about a marriage and a domestic relationship being concurrent. Which means that technically you're recognizing that someone is in marriage, is having one or more homénage.
Yeah. This is an issue.
Someone being in more than one homénage. You have a little problem because someone will tell to you, I'm married, I'm faithful, he is a cholapa. Before I could get maintained, or I have a right to get some maintenance or whatever, or even to get damages for adultery. Now, I can't claim damages. She comes, not only she pick up my man, but she comes and says, I want their property. You will have a problem with the people in your constituency. You have to be careful about these rules, because the consequences can be disastrous. And I'm just highlighting to you. Because right now you are permitting polygamy. You have to be careful.
Okay.
Yeah. I mean, I'm not saying you can decide to have it, but be careful about the implications of it.
We'll come to this.
Yeah, the implications of it.
Death.
One article has actually.
Just think about it. I'm saying you should do it one way or another, but think about it.
Let me give the mic to Honorable Sofola. Then.
Thank you, Mr. Chair. I was going to take the point polygamy too, because since this morning we've been talking about marriage. It seems that the law is putting weight on these two. Now, my opinion is, if we're moving towards this, so we're trying to say that polygamy will be soon legal in our law, because and this morning in 257 we've talked about adultery. Where does it stand in line with what we've just said?
Professor?
There is in the current law and in the bill no provision for polygamy, and the fact that there are concurrent marriages and concurrent on menage relationships, is technically at least not polygamy, because the en menage is not a marriage, whereas polygamy would suggest you have several spouses and that they have equal rights. The situation which the bill seeks to address is the fact that having en menage relationships is not illegal. It's not against the law here. So if that is seen to be equivalent to polygamy, well, you've got it. And then there are, sadly, the same sorts of problems arising out of the en menage relationships, particularly with the property protection for the non-owning partner. They tend to be the same as those that arise from marriage breakdown. You come back then to the question of justice and fairness and say, should the person who doesn't have the marriage certificate be disadvantaged vis-a-vis the property situation for the one who does? So if you have a marriage, 20 years duration, several children, there's a breakdown, there can be, under the present law, a property distribution for the non-owning partner. The same facts exactly, but no marriage certificate, and the non-property owning partner could go away with absolutely no rights, and technically at best get back any money contribution that they may have made to the property which is owned by the other person. So the starting point, as I see it, is that the multiple relationship situation exists, and the experience of the courts and I think the community is that problems have arisen when relationships of long standing break down, and the committee proposal sought, as the chair said, to or as Honourable George said, to address two specific issues. They are similar to the marriage situation, but they are not directed to marriage, either detrimentally or otherwise.
Thank you, Professor. Honourable George.
Very briefly, Mr. Chair, thank you very much. I think one thing that we must not forget is, one thing that we must not forget is that the situations that we're talking about are not going to come up because of the law. They are with us today, and they have been with us from time immemorial. What the law seeks to do is to address current problems without hopefully creating new ones. It is not the intention of the law to make concubinage more important and more easy than marriage. That is certainly not the intention.
Increase the responsibilities.
Yes. All that the law seeks to do is to find a fair solution to a situation that already exists, rather than create a new one. Today, there are people who are living, who are married, and who have a concurrent ménage relationship. We know a lot of these people today. And if the current ménage relationship ends today, the concubine will go to the court, obtain an order under unjust enrichment, which will decrease the patrimony of the man. So therefore, the married spouse will say, well, hang on a minute, look at what you've done. I'm now going to inherit less because of what you've done. This is current today, so it's not something that is going to happen. What we're looking at is how to address current issues.
Thank you, Honorable George. And probably like Professor Angelo put it, this might also increase responsibility on the married couple, either way, the man or the woman, hopefully. Honorable Dekomamo, and then Honorable Lawi.
Mr. Chair, thank you. This is one part of the code which I'm really not comfortable with, and I am dead against. I think it is wrong. We're not supposed to, in inverted commas, legalize polygamy. I see it like that. We are now, by means of this part of the code, saying it's okay to be a menage, you married, and to be a menage with 1, 2, 3 other people. And that is wrong. If it is wrong, we should be bold enough to say it is wrong and not acknowledge it and not condone. And we should put a stop to it. What we initially, I believe, the problem should be, the issue rather should be, is where one relationship, or menage, there's no marriage, someone has been living a menage and they have, out of this relationship, children were born and so on, and there is property, they started to build a house together and whatnot. Then at one time, this relationship breaks or one dies, then it is okay for the other one to benefit from that relationship. For me, that is one aspect of it, and that should be protected. We should recognize that while they wait to decide to get married. But where there is already a relationship, especially a married one, then that husband or the spouse, rather, to go and live a menage with someone else, they have to decide to annul their marriage. That is what they should do. And people in this country, in our small country, should be responsible. And with this code, we should bring that aspect on board. We have to be responsible citizens, and we have to decide properly to say, okay, my marriage is not working, so I decide to break it and to move on to a menage. This menage is not working, it stops, I go to another menage. It's okay, but one has to stop. I don't mean for me to have 2, 3. That is, in inverted commas, we are legalizing polygamy. If we're doing that, then we have to say so. We are doing that, and then we have to bring this to the to a referendum, rather. Thank you.
All right, Honorable Lawi.
Thank you, Mr. Chair. Good afternoon. In relation, continuing to what Honorable Dekomamo started saying in giving rights to people or encouraging people to have several relationships at the same time, I think we have to really decide on which angle we're going to go. However, I do understand when Honorable George says that there's issues in relation to ménage relationships, and I agree that property distribution is an issue when people are in ménage relationships, and there should be some kind of guarantee around that. But maybe something should be included that says that if you are in an ménage relationship with a married person, then you'd not have access to their assets. That would make somebody more responsible going into a relationship with a man or a woman who, for reasons of wealth, in that I know he has a wife, but I will entertain or put up with the relationship without standards or without putting meaning, just to live it out so that she can then or he can then claim something later on. Because when you go into marriage and you have vows, and one of the vows is to be faithful to one partner generally. And we have said that here in Seychelles we have circumstances where a marriage has failed, but one partner does not consent to divorce, even though the other partner wishes to live to leave the person, there's no consent. But we said we have included that as the fifth reason for divorce. If we're then saying after 5 years somebody claims divorce, consent is no longer required by the other spouse, then that means the person can get out of their marriage, can then start an emménage relationship. But I don't think that an emménage rights, which I think should be included, it's right that the property issue should be looked at, but if it's with a married person, I think the law should go further to protect the third party who is innocent in this arranged emménage relationship. So I think we understand the issues, but we have to go further to protect the sanctity of marriage. Thank you.
Thank you, Honorable. Okay, I've got a few more members actually on my list, but we're at lunchtime. I will give the final closing remarks for now to Professor and Honorable George, if you want to add something. Professor?
Yes, thank you, Chair, and thank you, members, for the contribution. The matter may well be crystallizing somewhat, and the result of the, as I understand the last two contributions, there, one way forward, if there is lack of support for the proposal that has been presented, would be to define what is emménage relationship for this purpose, and it may be to limit it to those where there is, it might be said, no legal impediment. In other words, these are people who, if they wished, could marry. And if it's adulterous, well, of course, they couldn't marry. So this is a monogamous union which hasn't had divine sanction. And that would protect a great number of situations. There may be still where there are multiple relationships, but the current law would allow them still to come with the unjust enrichment claim if they wished. So as I see it, there's many ideas, but there is also at least two supporting emménage, but with a particular, particularly moral-based definition.
Thank you, Professor. Honorable George, you want to add something?
Thank you, Mr. Chair. I think this is a good point for us to stop and take stock and decide whether we do want to define the relationship.
Thank you, Honorable George. Now, I've got Sarah, who's sitting here taking down notes and so on, and compiling at night. She made good sets of notes for yesterday. Do you all want to share the notes? Okay? Okay, we'll send, yeah, I think I've got a copy, Honorable George's got a copy. I'll send it to the Secretariat and copy to all members. Okay? Thank you, we'll take a break and we'll go for lunch and we come back at 2. Just a reminder, ABC members, we are meeting at 1:15, Speakers Conference Room. Thank you very much. Thank you, SPC.